Thank you for having me. It's great to be here. I'm really honored to get a chance to talk to you. And as someone who has done criminal defense cases for a living, I'm grateful that you've selected this topic of police practices and excessive force as a focus of your work. I only hope that I can be helpful to you in doing the work that you've set out to do and coming up with some solutions to this knotty problem. And along the way, as a side effect, hopefully I can tell you a little bit about police practices in Boston and maybe also convince you that this is what you want to do for a living, just on the side. So I want to thank Evelyn for the introduction. She did not mention that among my accomplishments is having learned precisely zero about giving a presentation or PowerPoint or using computers, which is a little bit embarrassing because one of the things I'm supposed to do in my job at the ACLU is to manage our docket of technology cases. So there's some tension there. So anyway, if there are any problems with the technology today, please just use that time to enjoy lunch. I'm going to start, I think, by showing you a video of someone who is emblematic of the kinds of complaints that we have received over the years at the ACLU of Massachusetts about problems with policing, particularly in Boston.
I have been robbed. These 4 guys driving by me had a gun. And just took out my wallet, took the money I had, and that's when he pistol whipped me. Looking down, I saw that I was dripping blood. I was about a block and a half away from E13 police station for Jamaica Plain, and the whole time I was contemplating whether or not I should talk to them. I got to the front of the station and I was just like, you know what, no, I'm not gonna waste my time. My name is Ivan Richez and I'm from Boston, Massachusetts, specifically the neighborhood of Jamaica Plain. I live on South Street, which is a Boston Housing Authority housing project. Most of the people there were Latino, Dominican, Puerto Rican. Aside from that, there was a lot of African Americans there. The first time I got stopped by the police was when I was 14 years old. I'm with like 2 or 3 of my friends, just hanging outside, chilling on the bench, literally right outside of my crib. It wasn't a good experience at all because I had no idea it was gonna happen. I had no idea that it could happen just hanging out outside of my own home. They asked us first, do we live there? What were we doing there? And if we had any weapons or drugs on us. We obviously said no, we didn't have any drugs or weapons on us. Then they asked us if they could search us. So they brought us inside the hallway. And that's when they decided to really search us, go into our pockets, check the lining of our boxers, inside of our socks. They asked for IDs. I was very compliant with them. After that had happened, I was confused and I had questions. I've been stopped by the police many times. If I were to say a number, I'd say about 30 to 40 times, maybe 50. I don't think I have any friends that have never been stopped. I'd say the police treat my friends very similar to the way they've treated me, where they just assume you're up to no good. If it's not the same, it's probably worse. I think the constant pressure of knowing that you could be stopped by the cops definitely has an impact on just how I carry myself and the amount of stress that I'm experiencing. I'm very aware when cops are around. I'm aware of sometimes whether or not I want to keep a hood on my head, whether or not I want to reach into my pocket or just look around and be a little bit more aware of my surroundings. It gets tiring because we literally feel like we're just criminals and they perceive us as criminals at all times. The feeling of criminalization is sort of feeling like you think you're a bad person, or you start internalizing the feeling that, you are a bad person, or that other people that look like you are bad people, where we start to hate each other or even not trust each other, where it should be the opposite. I've been a victim of an armed robbery. I was thinking the whole time whether or not I should talk to the cops. And I was obviously thinking, I'm not gonna go to the cops. I have never gone to the police for help. I don't see why I should go to them for help if they're constantly harassing me and asking me what am I doing in my own community. I see no reason to trust them. You could be stopped and be taken into a cell for absolutely no reason at any given moment.
So unfortunately for us, Ivan's not the only person who's come to us with this kind of problem. And so we have for years been trying to figure out how common this experience is and what could cause a person who has been the victim of a crime to get to the point where they don't even want to tell the police about it because they're so convinced that there's nothing good that will come of that. So over the last years, we have sought to get data from the Boston Police Department about its street encounters. It calls these encounters FIOs, which is short for Field Interrogation, Observation, Frisk, and Search, which basically means, the whole range of stuff we do to people on the street. And over time, we agreed with the BPD to do a study. They took 200,000 reports of these encounters. They coded them with the names, arrest records, and alleged gang membership of each of the people who were subjected to these encounters. And they did it for a 4-year period from 2007 to 2010. And the interesting thing about these reports, and something to keep in mind when you think about the spin that you hear from police officers about this data, is these are all reports that did not result in an arrest. People who got arrested were written up in a completely different set of reports. So whatever these people were doing, whatever they'd done in the past, they weren't doing anything at the time of these encounters to warrant their arrest. And because the BPD collected information about the prior arrest records and gang memberships of these people, the independent researchers who looked at this information were able to control for crime. So what did they find? The most striking thing they found, just right off the bat, is that although Black Bostonians make up, according to the 2010 census, about 24% of the population of Boston, they were 63% of the people subjected to these encounters. So for your frame of reference, I think your white paper mentions some of the numbers coming out of Ferguson. This is just in pure mathematical terms a greater disparity, I believe, than the traffic stop discrepancy that you saw in Ferguson. And of course, there was also disparities by geography. In Roxbury and Dorchester and Mattapan, places with high concentrations of African American people, you saw the highest concentrations of these encounters. The least amount of encounters occurred in places like Brighton and Charlestown and South Boston. This may come as a shock to you, but there is also crime in Charlestown and South Boston. There's just less police encounters. The other thing that really struck us off the bat about this data is the reason that was given for the vast majority of these encounters. It wasn't, I saw a hand-to-hand transaction. It wasn't, I saw someone casing a jewelry store. It wasn't, I saw an assault. It was, I did this encounter to investigate a person. Right? That is not a justification in a constitutional sense or even just a grammatical sense for why the police officers initiated these encounters. It's just a description of what the officer decided to do. And the analogy I would draw is to the stop and frisk study that was done in New York, where for many of those encounters, the police gave the reason of furtive movements. There was some kind of furtive movement, usually by the person of color, that caused me to have justification to initiate this encounter, initiate a stop or a frisk. This is worse than that, because I think the problem with furtive movement is it was unlikely to be true, and it's certainly in the eye of the beholder. But if someone does make a furtive movement, it's plausible that that could, in some situations, justify stopping them, right? Investigate person doesn't even do that. This is what the form looks like. And so we know that in 63% of these forms, the race is black. 75%, it's investigate person. And then, like I said at the beginning, these are encounters that did not result in an arrest. So it's not surprising that we see in only 2.5% of these encounters was there even a seizure of a weapon or contraband. Okay, so I mentioned at the beginning that the police were able to look for indicia of prior criminal conduct. We know these people weren't doing anything that warranted their arrest at the time of their encounters, but maybe they were just bad guys. And certainly that's, if you have done this research, which you have, you know that that's what you hear from police. They say, we're just going after the violence, we're just going after the bad guys. Well, they were able to control for that in 3 ways in this study. The first thing they did is they said, well, let's just control for violence in the community. And I mentioned Roxbury, Mattapan, and Dorchester at the beginning. So if you control for crime in the community, do these encounters go up as the percentage of the minority population goes up? Does that happen? Because it shouldn't, right? The other thing they looked at was whether, if you take just the population of people who were subjected to these encounters, were black people more likely than otherwise identical white people to be frisked or searched during the encounters? And finally, were black people subjected to these encounters more likely than otherwise identical white people to be stopped or encountered again? Okay, so they asked 3 different questions. They got the same answer. In each question, the answer turned out to be that race mattered. So, here are the bad guys, right? These are people that my office has been working with, leaders of the community, activists, people like Ivan, for whom their race matters when it comes to whether they are subjected to these encounters on the streets of Boston. Now, out of deference to the researchers, the study that we just released at the beginning of October doesn't get into the precise statistics that the researchers used. They're preliminary numbers, and although we don't expect them to change, and we have been given no indication that they will change, out of respect for the researchers, we wanted to wait for the final numbers to come out before putting them in a report. But when we released our report, the press called people and asked questions. And as a consequence, one number did come out. And the Boston Globe reported that for every 1% increase in the percent of the population that is black as compared to, say, white, you get a 2.2% increase in the number of these FIO encounters. So 2.2% sounds small, and if you look at some of the coverage of the report that was released, we released it on October 8th, you will see attempts to minimize the magnitude of these racial disparities. You'll hear things like, well, the study also found that we went after the bad guys. I mean, that's true. The study did find that, right? And that's like saying, well, you know, if you learned that an admissions officer at this law school was giving a really strong preference to people who were white, and you confronted them with that, and then they said, well, yes, but we gave an even stronger preference to people who finished first in their college class. Would that make you feel better? It's like, oh, that makes sense, so the racism is okay. But if you read the press coverage, you will see some people say, hey, this 2.2%, that's small. I know, you know, percentages go to 100. But is it great? It's not. And I mean, let's go back to the first thing I would say, which is that this study was controlling for crime. So if you take a community, whether it's in Dorchester, Roxbury, Mattapan, and you say, let's see what happens to police encounters as the percentage of the community that is black increases. If crime is not increasing, if gang membership is not increasing, if nothing else is changing but the color of the skin of the people in the community, then what should you see as that percentage increases? You should see nothing. You should see that the numbers of these encounters stay the same. And there'll be some baseline, right? It won't be zero because there is some level of crime. It'll be just the level of enforcement that the BPD chooses to undertake. Okay? Now, let's go back to the 2.2%. That's 2.2% increase for every 1% of the population that is black as opposed to white. And, you know, Boston has some white people in it, but the percentage of the population that is black is not 1%, it's 24%. So what that means is you're getting thousands upon thousands of these encounters that are occurring simply because of the presence of black people in Boston. So that's what the 2.2% gives you. And if you want to do back of the napkin calculations, you can think about it. Well, there's 2.2%, 24% of the population is Boston, and we looked at 200,000 of these encounters. So how many would there have been if the police stayed at that baseline? Well, it would have been a lot less. And this is relevant, I think, to your study of focusing especially on excessive force, because when people don't get subjected to these encounters, they don't get hurt during them. Right? Anyone can accidentally make a furtive movement. Anyone can walking around with an air rifle, right, can be looked at and thought, well, that person seems dangerous, that person doesn't seem dangerous. But if there's no one there around them with a firearm aimed at them, they are less likely to be hurt. So, that's not good. There are also systemic factors, as your white paper talks about, that are making this problem not only worse, but just harder to solve. And I don't want to repeat the things that you all have studied, but I do want to talk a little bit about the things that I've seen just in my work as in a federal defender's office doing criminal defense and now doing civil rights cases. So what I've seen is everything about this study was taking at face value everything the police said. So if the police said if the police arrested someone in the past, that person goes down as having an arrest record, regardless whether that arrest was justified. The police say that someone was in a gang, that person's in the study as a gang member. Right? He doesn't get to say, wait a second, I'm not actually in a gang. What are you talking about, right? Ivan, for all I know, might be in some gang database, despite not being actually in a gang. And we take it on faith that the police wrote up a report for each and every one of these encounters. Do I think that each of the 30 to 40 or 50 times that Ivan was stopped, I think there's a report for each one of those? I do not. I'll talk about that in a second. The other is, you talked about this, is bad doctrine, especially under 1983, qualified immunity. And then there's the drug war, and then there's access to records. Let me take each of those and talk a little bit about them. So to give you an idea of my perspective on the stories that come out of cases and the stories that come out of police reports, I'm just going to talk about, briefly, 4 cases that I handled. Now, they're not maybe that significant by themselves, but my point of mentioning that these are my cases is I didn't have to do an exhaustive Westlaw search to find these examples. I didn't even have to go back that many years, and I didn't even list all the cases that I could have listed, okay? I just listed these because I think they're kind of the most amusing ones that I have. So in each of these cases, an officer gave testimony that at least I found to be totally unbelievable. And in each one of those cases, the officer's testimony was viewed by a court as a reason to hold that the police conduct at issue in the case was constitutional. So in one case, an officer wanted to show that my client, Mr. Glover, was responsible for a car that was nearby. But he didn't have a way to do that. So he got my client's consent, so he said, to search his pockets. But he didn't have consent to sort of do anything with the stuff that was in his pockets. But that was okay, it turned out, because what he said was when he reached into my client's pockets, he accidentally hit the unlock button on the key fob in my client's pocket, that was on the keys in my client's pocket, and that unlocked the car and thus established a connection between Mr. Glover and the car. And that was really just really fortuitous, because as you all know from carrying your own keys, you're just constantly hitting the button by accident. And then in the case of Mr. Mubdi, there were, Mr. Mubdi and a friend were driving on a highway in North Carolina, and they were pulled over for speeding, but in an interesting way. They were pulled over by for speeding by a canine team tasked with interdiction, which means drug interdiction, right? And they had radar in their car, but they parked their car perpendicular to the road, thus disabling their radar. And that was okay, they said, because they were able to visually estimate that Mr. Mubdi was going 8 to 10 miles per hour over the speed limit. And so despite disabling their own radar, the courts deemed them trustworthy enough to trust their visual estimate of the speed of Mr. Mubdi's car. Then Glover, so the first one was Stinson. The Glover case actually was a case in which an officer's report suggested that he got my client's consent to search, but then it turned out there was a dash camera on his car. And that didn't really go well with the consent theory, because you could really see Mr. Glover being told to do stuff. So what did he say instead? He said, well, I made him give me his ID, but when he reached into his pocket to pull out his ID, he kind of cupped his hand. And I thought he was cupping his hand around a gun. And for my safety, I had to frisk him. The problem with that, again, there was a video, right? He didn't frisk that pocket. He frisked the other pocket. Nevertheless, Mr. Glover lost. I'm sure there will be a point at some point in this talk beyond that I'm just good at losing cases. And my favorite, really, although it's just terrible for Mr. Griffin, is that there was a case in which my client, Mr. Griffin, was stopped in his car based on a tip that someone gave face-to-face to an officer or officers. And I'm not sure, because the 2 officers who testified could not agree whether they were both present talking to the person who gave them this tip about the gun possessed by Mr. Glover. The one officer who was present, though, she was really sure that she was there and had talked to the tipster. The other officer wasn't so sure. What she wasn't sure about, though, was she couldn't remember the gender of the person who gave them the tip. Nevertheless, her testimony about this face-to-face tip was deemed as credible enough to have the tip alone be a basis for stopping Mr. Griffin. So it will shock you to learn that one common attribute of the defendants in each of these cases is that they were black. As you've noted in your white paper, there's also a problem of doctrine. It's just very difficult to hold officers accountable for misconduct. And that is especially true in the case of excessive force. This is a picture following a successful trial by my office against a police officer in Worcester, where we alleged that the smiling people in the middle are our client, Wakila Cocroft, and her husband. We won on account of false arrest based on a video showing an officer grabbing Ms. Cocroft and pulling her out of the car and using an armbar technique to wrestle her to the ground and leave her there for several minutes, based on basically talking back to him during a traffic stop of her sister. We won as to false arrest. We lost as to excessive force. So, right, this is a large, trained officer who, in the view of a jury, needed an armbar technique to wrestle that little lady down to the ground, on the theory that she pulled up her legs and sort of hunched as he was yanking her out of the car, because that's what you do when someone's yanking you out of a car. So it's hard. It's very hard to hold officers accountable in court, especially if you're dealing with excessive force. And the drug war makes it all worse. So in the Mubdi case, a judge wrote the first quote, which is that the doctrine that says you just need probable cause and you can just stop someone makes racial profiling possible, right? I know why Mr. Mubdi was pulled over. He fit the officer's conception of who a drug dealer is. It had nothing to do with whether he was speeding or not. Speeding was just the excuse for pulling him over. And everyone in the case knew that. But it didn't really matter, and that's why the judge who wrote that nice, helpful statement wrote it in a concurrence, in an opinion affirming my client's conviction. What we don't know is how many people the officers had to stop before they got to Mr. Mubdi, before they got to the guilty guy. And similarly, I know that you've looked at the militarization of police in your work. We're seeing that here in Massachusetts. I mean, the ACLU just released a national report on militarization of police. Our office released a report. And there's a famous case involving a grandfather named Yuri Stamps who was shot during a SWAT raid of his home in Framingham by a Framingham SWAT team. And he was complying with everything. He had no connection to the drug warrant that was being served. It was a relative of his. But an officer stumbled over and shot him and killed him during this raid to look for drugs. And it's undisputed in the civil suit that he has filed against the officer in the town of Framingham that this is what happened. But because of the doctrine and the drug war, you see this statement in the defendant's motion for summary judgment, because their view is the doctrine's so good for them that even under those undisputed facts, they get to win on everything but a simple negligence claim against the officer. So, but the good news, I guess, is that we've won the drug war, and there's no more drugs. Or if there are drugs, they're just really way more expensive and nobody can buy them. So there is some racism that happens along the way, but we get this great benefit, which is that there are no more drugs on the streets. So another problem is that just to talk about this, just to talk to you about the study, we're releasing a report in October 2014 about data from 2007 to 2010. So how does that come to be? Well, we've been trying for years to get it. And public records law is really tough. the first thing that happened was we were told that to get data for just 3 years of these FIO reports, we would have to pay $112,000. And we here at the ACLU of Massachusetts do not have the same kind of endowment, say, as other institutions do. So that put us in a difficult bargaining position, and it left us with the option of suing or working something out. And we tried to work something out, but as the consequence, what we're hearing now is, well, the data is old. Well, we didn't want it to be old. We wanted it years ago. Similarly, when we talk about the militarization of police, SWAT teams in this state are organized as law enforcement councils. And these law enforcement councils that run these SWAT teams take the position, which we're litigating in court, that they're organized as nonprofits and not subject to the public records law of Massachusetts. Right? So if we want to, they're like the Girl Scouts, but with armored vehicles. So that's their view. We just, if we want to know how many armored vehicles they have, what weaponry they have, whether they've shot anybody recently, that's information that we can't get from them, according to their view. And of course, as you have found, and I think this is covered quite well in your in the white paper, there's no national database of police killings. And so, whether your goal is to seek out injustice, to find out whether there's injustice, or to track militarization, or to find out who's alive and who's dead, you are going to have trouble just getting at the facts, let alone remedying the problem. So none of that's good. What should we do about it? Well, for those of you who haven't read a report, these are our top recommendations. And you might say, hey, you're supposed to fix injustice for a living. That's your job at the ACLU. Why would those be recommendations? And I say to you, sandwiches are delicious. Though that's not true. So what we did is we haven't just collected this information. We've been talking to people in the community. So this is a meeting of what is now the Boston Coalition for Police Accountability, attended by members of our staff, but leaders from all over the community. And we've been talking with them, people like Ivan, right, before releasing our report. And one reason we did that is that we didn't want to release a report that says, here are the considered views of the ACLU and the ACLU alone about the problem of policing in Boston. That's not the report we want to issue. And it's not the report we did issue. What we did was we tried to make sure that we advanced proposals that not only fit our conception of what would help, but fit the conception of the community. And so here's what we came up with, and I think you will see a lot of overlap between what we are saying and certain things that you are saying. So cameras. There are studies showing it more each day. There's the famous one from Rialto, but just a few days ago, the Columbus Dispatch did another story about how the police in one town that have tried cameras on eyeglasses are really happy with tracking, with video recording. And that's right, because you get better behavior by everybody when people are being recorded. Better behavior by the police, better behavior by the subjects. And when there is misconduct, you can actually get at the truth. And given my experience from the Fourth Circuit, maybe I'm a little shell-shocked, but I just think unless I see footage of what actually happened, I cannot trust an account in a report about an encounter between a police officer and a civilian. We also have proposed the idea of citizen receipts, which is every time whether it was 30 or 40 or 50. But every time that somebody has stopped Ivan on the streets of Boston, they should have handed him a receipt that says, here's why I stopped you, here's my name, and here's who you can contact if you have any concerns or complaints about that. That way, we and people who are affected by this police behavior can find out what is actually going on and do something about it. And then, of course, we want data. Police departments, including the police department in Boston, should be disclosing data contemporaneously about these encounters. Because we really can't address the problem if it's going to take years just to study what happened. And then, of course, the training. Given the chart that I showed you earlier about the effect of race on the numbers of these encounters, it is not sufficient to say, well, we're hiring a more diverse workforce. It is not sufficient to say, well, we're doing our best. We tell people not to be racist. Of course not. Of course you're telling people not to be racist. But what we really need is training to make sure that people engage in conduct that is strictly constitutional. And we'll see. I mean, we're hoping that lots of people, including you, will work on this problem, because it's a problem, as you know, not just in Ferguson, but here in Massachusetts. And we could use your help. So here's some more places to go. Our report's at the first link on stop and frisk in Boston. The second link is to a report on militarization, which sounds like might be helpful to you, given the focus of the white paper on your class. And then you can also learn about the Boston Coalition for Police Accountability. I think I managed to talk quickly enough so that I have time for questions, if anyone has any.
Were the Fourth Circuit cases that you were on all appeals based at the motion for summary judgment stage, or had any of them actually gone to trial, or were any of the pleading stage, I guess, third possibility?
So these were all criminal cases and arising from criminal convictions. I have to think back about the percentages, but for most of them, what happened is that they litigated a motion to suppress the evidence and then lost it and pled guilty under a plea agreement that preserved their right to appeal just the suppression issue. So most of the cases that I had where there were Fourth Amendment cases arose under that circumstance, where it was a guilty plea but where the client had preserved the right to appeal. I mean, the issue, again, goes back to data, which is that I got cases only if someone was found with drugs or a gun. The cases that we get as federal defenders, someone who just gets pulled over, who isn't then beaten up, I don't know how many people those officers with the human radar gun abilities stopped before they got to Mr. Mubdi, just on one day. But you can see why maybe it wasn't going to be likely that each one of those people would then sue. And certainly if they wanted to sue, it's not clear who would take their cases.
Hi, I have two questions about some of the solutions that you suggested. My first is related to the receipts, which I'm curious how that system could be enforced, because I can imagine a scenario where a young man says, I was pulled over and I didn't get a receipt, and the officer says, I didn't pull him over. And so it's just a he said, she said scenario. My second question is related, and it is about data. How would you be able to determine if the data reported was accurate? Because it seems like officers would be incentivized not to report the instances where they pulled over innocent individuals.
Well, those are related questions, and so I think I have a related answer. One thing is you obviously need buy-in from the police department for things to really work well. And we have a new police commissioner here in Boston, Commissioner Evans. We have a relatively new mayor as well. And they have both made commitments to really increase the quality of policing in Boston. We talk about One Boston. So in making these proposals, one thing we have in mind is that perhaps unlike in other places, we have reason to trust the good faith of some of our leaders. The other issue is you have to create a standard. It's true that there are always going to be derivations from it, or derogations of it, I guess I should say. But if you have a situation where everyone in Boston knows they're supposed to get a receipt, then people will ask for it. And it's true that we can't, if someone asks for a receipt and the officer says, this never happened, then that would not be a good time for someone to say to that officer, well, you better give me the receipt. That kind of confrontation is not going to go well. But I think what matters is that if you create a rule that it's supposed to happen, just like if you create a rule that every encounter is supposed to be on video, there are going to be instances where there's no video and the officer says, I accidentally turned it off. But if the rule is supposed to be that it was given, then not having one looks bad for the officer. The norm has to be that there's a receipt, that there's an FIO report for each one of these encounters, that there's video for each one of these encounters. And then if there isn't, and if someone comes forward and says, this happened to me and there's no record of it, the police should want a record because it's going to look bad for them if they don't have one.
I met one of the ACLU lawyers at the Ferguson conference that BALSA put on last month, and he talked about the receipts, and he basically was, usually with the receipt, multiple people have a copy, right? So there's the original receipt that the officer would keep, and then there's a pink receipt or the yellow receipt that the subject would keep. So basically there's always going to be multiple copies. So if somebody can produce one copy, the other side can't say it never happened because one side always has proof, theoretically. So I guess that was helpful.
Yeah, that's right. So I should recognize the attorney you talked to. That's probably Carl Williams, who's done a great job on this. And that's right. It's very much like the cameras in that sense, in that it's a record. The receipt is supposed to create a record not just for the subject of the encounter, but for the police officer. Now, it's true that the police officer could just give nothing and write down nothing. But the idea is the police will want to say, yeah, we did stop you. And you know why? You just engaged in a hand-to-hand drug transaction. That's why, and it says so right here. They don't have that right now. What they have is, investigate person.
Thank you. So I noticed a lot of the reforms you suggested were legislative, and those seem like really strong legislative changes. But do you feel like there is any kind of litigation strategies that might lead to reforms as well? Or do you think the doctrine is just so bad that you're going to have to work legislatively first?
Well, that's a good question. So part of the answer is that not all of these reforms would have to be imposed legislatively. I mean, some of them are just a matter of rules for the police department or practices for the police department. Sometimes we at the ACLU do sue people when we feel like change is not going to come through some other channel. And so I think our view here is we have to let things percolate a little bit.
Thank you. It was a great presentation, and your technological incompetence was not revealed at all. It was very impressive. I wondered if you could say a little bit about your transition into this kind of work. That's it.
So I've been on a very well-worn path that I'm sure people talk about all the time, which is that I went to a law school kind of like this one, and then I worked for law firms in DC, and then I left that to move to North Carolina, and I assume that's what all of you were planning to do. And I will say, it's been great. I really liked the firm that I was at in DC, but I got to go and work on injustice. And North Carolina is also a great place to live, by the way. And then from there, I got this opportunity to do a broader set of things here at this job. So for me, it was getting a chance to really learn how to be a better lawyer, because I was in court all the time when I was in North Carolina and at a firm that's more difficult. But really, I got to help people and improve the law. And then I got an opportunity to come here and do more than just criminal cases. We do some criminal cases. The case that we won, in which I argued about cell phone location data here at the Massachusetts SJC, that was a criminal case. But we also get to sue people, right? We get to make our own cases, and we get to choose our own facts instead of just waiting to represent the guy who was actually found with the drugs or the gun. So for me, it's been great, because every day I get to wake up and think of my job as adding justice to the world, or at least trying. And that's really fun.
So you did mention that there might be a litigation component of your strategy, and you also mentioned that you're looking for test cases. So in excessive force, if you're looking to sort of change a doctrine, sort of what are the facts that you're looking for in a test case that would make it most compelling for you guys?
Well, that's tricky. I mean, there are specific legal doctrines that we don't like and might want to challenge, and then there's practices. So if you look at the New York stop and frisk cases, that's both, right? Because they were trying to change the practices of the NYPD, but along the way they had to make all these legal arguments and win on legal issues that were not settled. That's very difficult in the context of a suit under 1983, because often you have to show clearly established law in order to win, in order to overcome qualified immunity. So, I can give you a specific example, which is that in the Cocroft case, the smiling, victorious people emerging from the courtroom, one of the issues in that case was whether she could win on a false arrest claim because she'd been convicted herself of resisting the arrest that we said should never have happened. She resisted, again, by pulling up her legs, so she's a big-time resistor. Because the law in Massachusetts says if you are arrested for no reason, if a police officer arrests you because you have brown hair or dressed nicely, then you have to just submit to that and then sue later. You can't pull your arm. You pull your arm back while an officer arrests you for no good reason. That's illegal in Massachusetts, and that's what happened to her. So the issue we had to litigate in that case was, can you then, if you do that, if you're guilty of false arrest, can you go and can you still sue the officer for initiating the false arrest in the first place? We said yes, but there's at least one district court in Massachusetts that has said no. So, I mean, usually the way these things work in the 1983 context is you have incremental changes to doctrine on the sidelines of this problem that you have to win under clearly established law. But I think it's very difficult, and that's, I think you're finding that in some of the work that you're doing in this project.
So that's about all the time that we have for questions. Can we give a round of applause for Matthew Segal for being here today?